The next case to come before the court is Lorain A.M.No. Everyone ready to proceed on that case?
Yes, Your Honor.
Each side will have 15 minutes, and the appellant may reserve up to 5 minutes for rebuttal. If you so choose, just let me know. I would caution you to both sides that we do videotape, and we try to respect the privacy and of the children involved in these cases, as well as so please don't mention names, as well as when you're referring to mom and dad, if you refer to them with mother and father or something along that, so that we don't have the names out on the videotape. Thank you.
Thank you, Your Honor. Good morning. May it please the court. My name is Kathleen Amerkanian, and I'm here on behalf of Mother. This is an appeal of the grant of legal custody of 3 children to maternal great uncle and great aunt, and a corresponding denial of Mother's request for a 6-month extension of temporary custody. The standard in whether to grant legal custody to somebody is best interests of the child, and those prongs are set out in 2151.414. However, in this case, although the court does have ample discretion to determine what is the best interest of the child, the denial of an extension of temporary custody after Mother was only given about 5 or 6 months to work her case plan, I would contend constitutes an abuse of discretion, especially under these circumstances. Mother's case plan required her to address mental health, address substance abuse, required her to maintain housing, and just demonstrate her ability to provide for the children's basic needs. She was also required to do some form of domestic violence assessment because one of the concerns was that she had been the victim of domestic violence. In this case, this was not a case where a parent sat around, did nothing, and then all of a sudden, right before the hearing, got their act together and checked off a few things on the list. In this case, Mother did start. She had an assessment at Genesis House for domestic violence. She did have a psych assessment pretty early on in the case plan. It was recommended to her with regard to her substance abuse that she go for individual counseling rather than get treatment in a group setting. She did this. She started at Firelands in September of, I believe, 2014. The legal custody dispositional hearing was in May of 2015. So she did start in September of 2014. As a single mom, she's a single person. She's also working 30 hours a week. She's working nights. She did have some struggles with transportation. So she missed 2 appointments at Firelands, and per that program's criteria was discharged from that program. After being discharged from that, she immediately called Psych and Psych, which was closer to where she lived. Because of the function of Psych and Psych's schedule, her first appointment then with Psych and Psych was a couple months later. This was through no fault of Mother. Her counselor from Psych and Psych testified that Mother had been very engaged in counseling, Mother was making substantial progress, and that the counselor believed that she should be able to complete her treatment within just a few months. However...
Within 6 months, wasn't it?
What's that?
She would complete within 6 months, I think?
Yes.
Which stretched out to possibly 10 months, they said.
Well, depending on her compliance or attendance, and depending on whether she missed any appointments. However, this was the only sort of expert that testified concerning her compliance with the treatment and concerning the expectation of her being able to complete her treatment. children's services and also paternal or maternal aunt and uncle seemed to argue, well, because mother had missed some appointments in the past, that this established a pattern that she was not going to be able to meet that deadline. However, the standard here is not, I mean, the court can only, go so far in terms of looking into the future. I mean, the question is whether she was in substantial compliance with her case plan at that moment. And I think it's undisputed that there was expert testimony from the mental health counselor that she was making good progress and her prognosis was good.
What was evidence of the progress? Because she was continuing to test positive, correct?
Well, she had tested positive once, I believe, for marijuana. Is that what?
I think it was marijuana and cocaine over.
Yeah. And she believes that, and I can't remember where in the transcript it is, but she believes that she had admitted to using marijuana.
Will you tell me what the progress mother made, because that's what we're talking about here.
Well, the progress mother made was that she was, you can look at the other prongs. She maintained housing, she maintained employment, she maintained, there was never a question as to whether she would be able to, feed the children or put a roof over the children's heads.
She provided basic needs.
She provided basic needs. She attended visitations. There were some.
Well, they said that she had missed 10 in 2 months.
She had rescheduled, she testified, she rescheduled some of those visitations because to occur with maternal great aunt and great uncle outside of the agency because of the obvious challenges in, visiting with 3 children within the confines of an agency, a room in the agency. So, I think that the
What
fact.
about the relationship with the abuser?
She had testified that she was completely finished with with a relationship with him, and
Was that inconsistent with what her actions actually were, though?
well, at the time he was in jail, so there certainly was no physical contact. There was testimony that she had been seen with him, and I believe the portion of the transcript said Palm Sunday of 2014, which was before the case began. There were emails that he had sent to her. However, there was no indication from her that she was intending to resume a relationship with him. So no, I would argue that there was nothing on her part that established that she had any intention of getting back with him. The other part of the sort of theme that runs through the dispositional hearings are really whether there was a lot of focus on the great aunt and uncle's ability to provide more for the children in terms of financial support. There was questions to mother, how are you going to take the kids to their extracurricular activities? How are you going to afford their private school tuition? One question was asked to her, do you ever take your daughter shopping? And really the question before the court is not who can do the most financially for the children. The question is whether mother can provide for basic needs. And I would argue that any focus on one party being more financially well off than mother would be an abuse of discretion.
As I recall, one of these children was special needs or had
The youngest child
Was she able
with
to-
special needs, and there was no evidence that she had not been able to, or would not be able to take him to his doctor's appointments. There was a provide-a-ride provision through his insurance that she would be able to take advantage of. The children had been in her care for, when you look at the best interest factors and look at the custodial history of the children and the interrelationship between them and mother, the children had been in her care for most of their lives. They were not in and out, but mother children.
Is there a guardian ad litem in the case?
There was, and he testified that he believed it would be in the best interests of the children to remain in the care of the paternal or the maternal aunt and uncle. Some of his testimony, however, and testimony that the court cited in its journal entry was inaccurate. He stated that, for instance, that she had not followed up on the mental health component of the case plan since being discharged from psych and psych, or from Firelands, which was untrue. I think the Children's Services would even concede that.
Counsel, you're down to just a little less than 5 minutes. Did you say you wanted to reserve time?
I did not, but if I could,
Okay,
that would be
that's what I
great.
thought. So that'd be fine.
Okay, I will reserve the remaining time.
Sounds good, thank you.
Good morning, Your Honors. I'm going to, if the court is okay, I understand we're, Children's Services and I are splitting the 15 minutes, so I'm
That's
just gonna,
correct. I'm sorry, I should have mentioned.
I'm just gonna put a little timer so that I don't cut off
That's
counsel
fine.
for.
However you two want to divide it up.
We
that's fine.
talked about it, we're gonna each take about 7.5 minutes.
Thank you.
So thank you very much. May it please the court, my name is Wayne Nickel. I represent the maternal aunt and uncle in this matter. I just want to address some of the things that were brought up by counsel for appellant. First, with regard to the substantial compliance with the case plan. With regard to the mental health component, the testimony was that the mother had been terminated from the program at Firelands because of missed appointments. And then she immediately made arrangements to get into another program. I'm not certain what the court's definition of immediately is, but it's my understanding, my recollection of the testimony and the evidence that was presented was that mother made arrangements while the case was pending to get involved with the psych and psych program. And then she only had, at the time of the trial, now remember, this trial lasted, it was over the course of several months. I believe it commenced in May, and there was another hearing on July 19th, and finally finished in August. So we have 3 months, actually 4 months, that it lasted while the case was going on, and mother actually missed nearly a third of the appointments with psych and psych. So her
During the pendency of the hearing?
during the pendency of the hearing, when
Can that be considered? They
Can-
filed their motion for legal custody. Can the court consider what happens during the pendency of hearings, or do you only look at what happened before the legal custody motion was filed?
Well, I think the court can consider it, Your Honor, when you're arguing substantial compliance, and if there's something that's going on, and if mother needs to continue to address these concerns, and during the hearing she continues to miss appointments, which was the reason she was terminated from the Firelands program. Psych and psych apparently is a little more lenient with missing appointments.
Let me
and-
ask you this, if mother had been compliant and gone to every single appointment during that 3-month period, I would assume CSB would stand up and scream bloody murder and say that's not what we're here about, because she was given sufficient time before.
I would agree with that, but I think just going to the appointments, and I think that's what counsel for appellant was alluding to, that substantial compliance, well, she was going to the appointments. Well, first of all, she wasn't. She was missing appointments. And then two, as you asked, Your Honor, was she compliant? I mean, the counselor came in and said she was engaged and she was going, yet she admitted that she missed those appointments. But there was really no testimony that she was making actual progress on addressing her mental health issues. There's nothing of substance given by the counselor that was called by mother to substantiate that she was making progress in addressing the very concerns that were part of it. Just going to a meeting, is, in my opinion, isn't enough to address the concerns that led to Children's Services filing what they filed. So in terms of substantial compliance of that component of the case plan, I respectfully disagree that mother was in substantial compliance with that. With regard to the domestic violence component, there was testimony that mother completed an assessment with the Genesis house, but that was it. There was no follow-up, and more concerning is, and I believe that the testimony of the counselor indicated that they had not addressed the domestic violence component in their sessions. So again, in terms of substance in the sessions, domestic violence wasn't being addressed. And there was testimony from the children's services worker that I believe that maybe the first or second time that she met with mother had a black eye. And the perpetrator that was involved in this case, mother maintained contact. Physical contact when someone's in jail, no, there was no evidence presented that mother ever physically went to the jail to visit this perpetrator. But there was testimony, there was emails sent, and mother, I believe the testimony of mother was that she expressed her love and said she will always love this gentleman.
I'm not sure why that troubled everybody so much. Isn't that, I mean, people get divorced and they say, oh, I always love the person, I can't live with them. They're not good in my life. That doesn't mean I don't love them anymore.
The idea, Your Honor, was that she had this love for a guy and would put her personal issues, her personal desires, for lack of a better term, ahead of the children's.
If there's evidence of that, that's different, obviously. But just the fact that she professed love for him, yet, I'm not sure I'm understanding that point. But
Well, the concern was, I believe, that once this perpetrator got out of jail or was not in custody, they would resume a relationship, and if she had the children at any point with her.
But did she testify that she did not intend to do that?
I believe that was her testimony, Your Honor. But her testimony and some actions are inconsistent with that expression, would be our argument, Your Honor. With regard to the financial, I don't believe that was central to the court's decision making. I don't think the court led any weight to the fact that the maternal aunt and uncle were able to provide a decent standard of living for these children. I think that just their ability to keep consistency with these children, the routine that was testified, that maternal aunt testified, the calendar that she has with all the various activities of these three children, I think was compelling that they were able to maintain that and the consistency in these children's lives. They were thriving in my client's care.
And I think that's a reasonable assessment of that, and that's reasonable to look at. But do you think it's reasonable to ask questions about how are you going to financially afford to keep them in extracurricular activities? Why is that really relevant?
And Your Honor, counsel I don't recall seeing that in the transcript or recall that part of
And
the.
we'll read that, obviously.
Certainly. I don't recall that line of questioning. I think maybe the line of questioning was more in terms of keeping them in their routine that they've grown accustomed to. Really, the one child, the child that had special needs, was more concerning that she had to get to those appointments. They were, I believe, weekly appointments.
Transportation issues.
Transportation issues, yes. So,
Was mom able to get the child to the appointments when she had custody of them?
my understanding was no, that she was not able to get to the appointments. I don't think that was part of the reason that was part of the case plan, that she was required to do that. But there were times that maternal aunt would, I just want to check my time, I'm sorry.
Yeah, you are actually out of time.
Okay, then I will let counsel for Children's Services finish up. Thank you, Your Honor.
Thank you. Time flies.
Thank you.
You may proceed.
May it please the court, my name is Emily Kirsch and I represent Lorain County Children's Services. Before I address mother's assignment of care, I would like to first address an issue that was raised in my brief, in that this court should dismiss the appeal for lack of jurisdiction as it was untimely filed. According to Appellate Rule 4, a party who wishes to appeal from a final appealable order must do so within 30 days, and failure to do so is a jurisdictional defect. In this case, the The board issued its final appealable order on January 4th, 2016. 30 days from that was February 3rd, 2016. Mother did not file her notice of appeal until August 5th, 2016. Mother claims that she wasn't properly served with the final judgment. However, the evidence establishes that it was sent to Mother's last known address. So
But wasn't there an issue about the post office, not the post office, the clerk arbitrarily changing the address based on a forwarding order from the United States Post Office?
Yes, Your Honor, the clerks did do that. However, the address that Mother still had with the clerks was 206 West 29th Street. And the evidence established in the contested hearing that Mother was evicted from that home. Therefore, even if the clerk hadn't changed the address, it would still be sent to an incorrect address because Mother did not take the step to formally notify the court of her new address. This is a case where Mother was represented by an attorney as well, and her attorney did receive notice of the judgment. There's nothing to dispute that he didn't receive it.
Except that it was by the court mailbox, right?
That is
And
true.
isn't there case law that says that that's not sufficient service?
There may be, Your Honor.
I'm just, you know,
But, and I would still submit, though, this is a case involving children, and to file an appeal 6 months later, to not take, a person has the duty to keep themselves informed of the proceedings, especially when it involves your children,
and the court has a duty to make sure the service is adequate.
That is true, Your Honor, but I do believe that regardless of whether or not it would have been served to the 206 address, or the Lexington address, we would still be in the exact same position. I believe that Mother also invited this error. If you look at the court filings that Mother's attorney did after the objection to the magistrate's decision, that attorney was still using the inaccurate address. Therefore, all the confusion I would submit was Mother's error. To address the assignment of error as to the case plan progress. So there were 3 case plan concerns. The first one was that Mother's marijuana use was negatively impacting the children. The testimony established that Mother did not engage in drug and alcohol treatment initially.
And let me just cut to the
Yes.
chase. And obviously I've read this, but what did you say, how did the marijuana usage negatively impact the children?
It was negatively impacted. When the agency initially became involved, the caseworker testified that it was impacting her ability to watch the children and provide adequate supervision for the children.
In what manner?
I don't know if there were very specifics about it. It was just
This is all interesting to me since we're talking about legalized marijuana now all the time and medical marijuana, how that's going to impact. That's the reason why I was looking specifically to, as you would say, just like we would have with alcohol, because
Yeah.
it's not illegal to drink. So how does that impact your parenting ability? So that's fine.
And I don't know that there was
I'm-
specific in this case as
And
to
we'll look at the
that.
record. I just thought you could maybe pinpoint something specific.
But I will also note that Mother did test positive for cocaine in December 2014. During the pendency of the trial, she also tested positive for marijuana. With the domestic violence aspect of the case plan, Mother did complete an assessment at Genesis House. However, she was not able to receive services there because she was still in a relationship with the abuser in this case. Therefore, it was agreed that she would address it in the domestic violence, in her mental health counseling. Ms. Dukes, her counselor, testified that they were not addressing domestic violence because Mother told her counselor that she had completed the services. Therefore, even though Mother was in counseling, she wasn't even being honest with her service provider. The testimony also established that Mother had not demonstrated the behavioral changes. The case plan is not a checklist. There must be behavioral changes. The testimony established that Mother angered easily, she would threaten the caregivers in front of the children, and she was described as being verbally abusive. As to the basic needs, the testimony established Mother could not meet the basic needs of the children. Mother was evicted from her housing right before the contested hearing for not paying rent and not keeping the home clean. She was struggling financially. During the pendency of the trial, she had to borrow money from the caregivers because her gas was being shut off and she couldn't afford car insurance.
By the way, it was the caregivers who actually evicted her, correct?
Who actually,
Evicted her.
yes, Your Honor, because they were the landlords. Additionally, as to the medical needs of the children, the testimony established that the youngest one had 6 to 7 appointments per month and mother only attended approximately one per month, despite being offered transportation to all the appointments by the caregivers.
What was the, Judge Theodosi asked this question earlier, what was the state of the evidence prior to the children being removed from mom's home as to the special needs child and her getting into his appointment?
I don't believe that that was something that was really focused upon, but the issue was, would she be able to continue to do it? And throughout this case, and throughout appellant's argument, there's been questions about transportation. However, the caseworker testified that during her time in the case, mother never reported any issues with transportation. Mother had a vehicle, therefore this whole issue of transportation was not necessarily a true issue. As a result, the evidence established that mother did not make significant case plan progress, and she would not be able to make significant case plan progress. The evidence also established that it would be in the best interest of the children to be placed in the legal custody of the custodians by going through those 2151-414-D1 factors. And
Did the children express a desire?
Your Honor, the older two children expressed a desire to remain with their caregivers. The guardian ad litem testified that the youngest one, he had some medical needs, so was not able to express himself as much. However, he appeared to be happy and comfortable there, and the guardian ad litem was recommended that that child be placed in the legal custody of the custodians.
Thank you.
Thank you.
Thank you. Thank you, counsel. I'm sorry, you have your rebuttal time.
Thank you. I think it was said by counsel that mother continued to miss more appointments during the pendency of the case. I went back and looked through. I believe the first hearing was May 18th, 2015, but in the last hearing was August of 2015. The mental health counselor did not testify until August of 2015. So I don't think that there's any, perhaps I misunderstood counsel's argument. I don't think there's any basis to argue that after the mental health counselor testified that mother continued to miss more appointments. Also, it was argued that there was nothing testified to by the counselor as far as substantive progress that mother was making. However, the counselor talked about exactly what issues they were working on. She talked about, and this is in the transcript, like 287, she talked about they worked on stress management. That was one of the issues, this anger management portion. And so they were working on that. The counselor testified that mother followed through with treatment recommendations, that there's been no issues. The counselor also testified that mother had stated she had gotten DV, domestic violence counseling through prior provider. I don't believe that mother ever claimed that she had gone through the whole program of Genesis House. The counselor testified that the most immediate concern for mother was the mental health issue, and that as treatment went along, that they would be able to work then on the substance abuse and on the DV component, because the treatment could evolve in that way. With regard to mother being verbally abusive, it's important to note also that, you know, it worked both ways. The caretakers also were witnesses who testified that they had physically, excessive physical discipline with the children, that the children were one of the children, especially the girl, was witnessed being in tears because of one of the caregivers' anger toward her. And so I think that there was definitely conflicting testimony as to, there was nothing specific about anything that mother had said or done that had actually, you know, harmed the children or jeopardized their safety.
Didn't she say something to one of the caseworkers that would perhaps give someone pause? I don't have it in front of me. Like, beat your head in comes to mind, but I don't want to quote
She
something
said
that's
something to
not
the
there.
effect that the caseworker was lucky she didn't do it.
Okay. I don't recall that. However, I think that you
That's in the
see
brief.
that you see that a lot with frustrated parents when you have somebody taking your children away. I don't think there was any indication that the caseworker, I don't recall any testimony that the caseworker ever actually felt threatened or that it had ever gone beyond sort of a general like expression of extreme anger. However, she was working on that, and her expressions to the caseworker, I think, can be taken with a grain of salt. I think what's most important in these kinds of cases is looking at how their behavior affects the children. And I don't recall any testimony as to specifics as to how the children were affected by this behavior, by any of the concerns that the agency had raised. If I still have time, I would like to briefly.
You have about 30 seconds.
Okay, well, the jurisdiction argument, the address, the journal entry was sent basically to an address that doesn't exist. The clerk had been provided with a correct address in the form of a precipice by the prosecutor. And, the argument that, oh, mother's counsel messed up, well, I think that helps mother because, what is she supposed to do? I mean, she doesn't know how to navigate the court system. If her counsel is doing something to keep her from getting notified and her counsel also does not notify her, I don't know how she's supposed to stay informed. She did.
Was it mailed to the last known address, or was it mailed to an address that does not exist?
I believe and I did lay this out in the jurisdiction, in the memorandum in support of jurisdiction, that it was an address that did not exist. It was very close to an address where she did live. So I believe it's reasonable to conclude that this was a post office error and nothing that mother did or did not do. In fact, she's the one who, by coming to the courthouse and inquiring as to what was going on, that's when she found out that final judgment had been entered, and that's when she was properly served. She filed her notice of appeal within 30 days
You're
of
out of
that.
time.
Thank you.
Thank you. The court will take the matter under advisement and will issue a written opinion that will be sent to both sides, and we also will release it on our website. Thank you very much for your presentation.
Thank you very much.
It's very appreciated. Thank you.